Brian start? Okay, thank you.
Just want to say thank you for your lunch meeting. Are you ready to receive my sandwich?
Turn your volume up, and I'm going to turn this.
Alex, by any chance, did you receive my sandwich in your desk, or I'm still waiting?
You had a half, Cesar.
No, I'm just.
Hey, should I bring it to you? Are you okay?
I'm okay.
I have a half a sandwich.
Thank you, sir. No, I did.
Oh, you have
I ate already. I was just kidding. Thank you.
You want to turn yours up a little bit?
Yeah, I turn it up.
It's nice to have Alex in the same office, right, Cesar?
Yeah.
He'll make sure that you're well fed.
You'll never go hungry with Alex.
That's right.
I'm gonna take it as a good compliment, okay?
It's a rule. Alex must share his sandwich with all of us.
Hi, everybody. Hi, Cesar.
Hello, Oscar.
Hey, Oscar is there too.
Nice to see you.
Hi, Peter. What are you guys doing?
Oscar, did you receive your sandwich?
A sandwich?
Yeah, provided by Alex.
Alex was buying sandwiches for everybody.
See you guys missing?
Oh, when?
Virtual sandwich.
Can't taste it through Zoom.
Exactly.
Well, at the way we're going, very soon we're gonna be doing everything online, even eating.
That's possible, yeah.
Oh, I see. Now I can see what you're talking about. You owe me a sandwich. Alex.
Hi, Steve.
Return it. No,
Good afternoon.
I'm just kidding.
Hello. How
Hey, yeah. Are we going to have any handouts? No, I don't think so.
Yeah, it's okay like that. The volume. The volume is okay.
So, Brian, we don't have any handouts, right? I mean,
I haven't sent it around before.
Okay.
I can email it to you at the end.
Yeah, maybe can you do that, please?
Yes, I'll email it at the end to the agent, to you, Peter.
Yeah, to me
And then
first,
you-
and then I will you blast
And
it to
you
all the.
can, yeah, you can circulate.
All righty, what I'm gonna do is the following is 2:03. We'll start sharp. We'll start sharp at 2:05. What I'm gonna be doing is muting everybody, so you will have to unmute yourself to speak, okay?
Sure.
Okay.
And if I hear noise coming out of your screen, I will mute you. So if you have any questions, unmute yourself and address the question, or you could always write it into the chat box, all right?
Okay, maybe I'll introduce Brian first.
There you go.
Okay, welcome everybody, the Co-Banker George, and thank you, Brian, for coming to talk to us today. And you guys are going to have a real treat today because Brian is a very experienced litigator, and he's a partner of Sells, Ehrlich, and Mack. And he's been with the firm. Well, this is the the new firm he joined this year used to be working for what's Casting and Manning's. Is that right, Brian? And it's been many years, but
That's
and
right,
he has
yes.
extensive litigation experience, and anything that you want to ask, you're afraid to ask, but you want to ask today is a free treat for you. This is the only time that he won't charge for your legal questions, okay? So Brian, let's take it off. Take it away.
Okay, sure, great. Thank you, Peter. Thanks so much. And yeah, like Peter said, I'm a real estate attorney at Zelms, Ehrlich and Mack over in the San Fernando Valley, Woodland Hills area. I've done a seminar with you all last year. I've met just a few of you, but that's a good thing because just we don't have that many lawsuits to deal with at the company. So not really a good thing if I had met all of you actually before. So just going to walk you through some of the ways and strategies and things for you to keep in mind to be closing deals, getting your commission, but staying out of lawsuits and staying out of lawyers' offices and the problems that come along with that. So I'm going to walk through my outline. I'll scroll through it, and I'll have some examples for you all also. And just here's my web address. You can look me up on there, and I'm going to, like I said, email around the handout. I'll provide my email address and phone number to you, and I'll leave some time for questions at the end also here, everybody. So just going into ways for you to stay out of trouble here, stay out of lawsuits as a real estate agent here. And the first thing and I'm saying as a real estate agent, so be sure you're acting within your scope of your experience and duties and your role and your independent contractor agreement with your broker. Be sure you're acting as a real estate agent. That's the first way to stay out of trouble. And keep in mind, there's differences between being a sales agent and a property manager. There's a different endorsement on the license for property management. Your independent contractor agreement with your brokerage, it probably excludes property management responsibilities. You need a different agreement with your property owner if you're going to be acting as a property manager, and it gives rise to different responsibilities. Another common area where we see problems with acting outside your scope as a real estate agent is acting kind of like a loan advisor, a mortgage broker. Watch out for and don't make comments like, yes, you'll qualify for this loan, things like that. The advice should be, I want to help you out here, and I have a friend who is a mortgage broker. Let me refer you to him. Maybe you consider yourself a real estate agent and a business advisor. I had a case like that this past year, and I mean, sure, buying or selling real estate, it is a business venture, it is a financial venture, but it's, as a real estate licensee, you're not really acting as what we usually hear of as a business advisor or financial advisor. That's a different capacity. Maybe, for example, you're a tenants agent on leasing that commercial space on Colorado Boulevard in Pasadena to open up their new store, and you get the lease, and they're going to have their space, but your business owner, they're going to open up that store and ask you, well, do I need a city business license for this? And you say, oh, no, you don't. No, it's so easy. Or you say something like, maybe you don't say that, but you say, oh yeah, I think you do, but the application process is really easy. Those would be things that would be crossing venturing outside of your knowledge, training, and experience as a real estate agent. So try to stay away from that, please. I just finished up a case in October with a real estate agent, fortunately not with your brokerage, with a different brokerage here in Los Angeles. and it was a pretty contentious, tough case. And it was about, was she acting as a business advisor or as a real estate agent? And what made it tough for me to defend this case was the signature block on her email said the name of her real estate brokerage and real estate agent, and then below that said business advisor, and it had a website which she set up herself for her role as a business advisor for certain types of sales businesses. And when I was arguing, well, she wasn't acting as a real estate agent, made it a really hard job for us defense attorneys when right there on her signature block it had these two business capacities. So if if your email, hopefully none of you it's not, but if your email indicates these two roles, these two hats that you're wearing, that email signature block should be reconsidered. Okay, and then documentation of your files, flyers, advertisements. So starting out your transaction, what are some of the first things you're going to do when you're getting into it? Well, representing a seller, let's start with a seller. You're probably going to have you're going to have a listing agreement, and then you're going to prepare an MLS. And how are you going to advertise this property? Well, keep in mind, California Civil Code 1088 holds you responsible for the accuracy of anything that you say in an MLS. And I understand you're selling property, you need to close deals. Everybody has to make a living, but we need to kind of just hold ourselves back with some of the language that we're using in these MLS ads, or at least be careful with them. What if you're selling vacant land and you put in your MLS ready to build? Well, that's a pretty broad statement. I mean, ready to build could mean that you have the zoning, the soils are good, there's no environmental problems. Ready to build could even, a buyer could understand that to mean a guarantee that you'll get your permits. So why not, instead of ready to build, say, it's zoned residential? So just state the zoning of the property in your MLS. But ready to build, that could be interpreted to mean there's going to be no impediments, no problems with building that $3 million house on this property, and could open you up into a claim. Okay, so some of your fundamental documents. Okay, so now you've got your listing agreement and you've got your MLS up, so you're getting going here. What are some of the other documents that you're going to be using as a listing agent here? Well, your disclosures, like your AVID, your agent visual inspection disclosure, of course, and your TDS. Let me talk to you first for a few minutes about your AVID. And what I want to, this is kind of the same kind of thinking as with how do you prepare an MLS, is that your AVID, it's meant to document problems that you see at the property. It's not meant to be a description of every room of the property. So your AVID should say, master bedroom, cracks on the wall, shower door uneven. It shouldn't say, master bedroom, beautiful carpet, walls are painted white, and marble countertops in the bathroom, Kohler sink. It shouldn't just be a description. It should not be a description of the room. It should be a disclosure of the problems, because when your AVID is a description of every room, it becomes a buyer may view it as a representation that there's no issues at all in that room. So then if you're saying, brand new flooring in every room of the house in your AVID, but it turns out when the buyer moves in that, the flooring creaks, there's some cracks in it, they may make a claim. And when they do, their attorney, good chance their attorney is going to convert that into a fraud claim that the agent went overboard with how the property was described. your other fundamental and legally required disclosure by the seller. And I'm going to get to that. It's not really your disclosure as the real estate agent. The other fundamental disclosure in your residential real property transaction. And by the way, that's, most of what I'm going to talk to you about today is, selling your single family homes. The fundamental disclosure being the TDS under Civil Code 1102. And it's a seller's disclosure. It's not a real estate agent's disclosure, because the burden of the disclosure responsibilities is upon the property owner rather than the real estate agent. Not to say the real estate agent doesn't have disclosure responsibilities, but the lion's share, the majority of these disclosure responsibilities are upon the seller, not the real estate agent itself. And your TDS, it's completed by the seller. You should be sending the TDS to your seller with an email that reads like, here's the required disclosures for you. Please complete it, answer all questions, sign and date it, and return it to me. I have had some cases where the listing agent completes the TDS, him or herself, and that is a real concern. So keep in mind, it is a seller disclosure. Transmit it to your seller. Ask them to return it to you. Now, can you help? Can you walk through it with your seller? Can you assist your seller? Yes, you can, but you shouldn't. I like to say, I don't like to see your fingerprints on the TDS, other than that box towards that space towards the end where you confirm that you're providing your Avid. And there's just about 3 boxes under there. And then there's about 3 lines under there where the real estate agent will acknowledge that there's an Avid, and it has a space for the agent to make a disclosure. But other than that, this TDS is a seller's responsibility. It's not a real estate agent's responsibility. And, along with things like your Avid, with disclosures, keep your notes on there, literal, simple, and don't make conclusions about the cause of problems. So, what if you say in the Avid, you're walking through the property and there's the patio in the backyard of this, beautiful house in Encino, but the patio has these cracks in the backyard. So what do you note on your Avid? I mean, you write typical cracks on there as a listing agent, but could buyer's agent and buyer understand typical to mean it's standard, it's normal, so therefore it's not a problem? Possibly. So wouldn't it be better to write on the Avid, cracks in patio from back door to pool, something like that? What if you put, in the Avid, minor stains? Well, maybe it's not minor to you. Or, smelling downstairs bedroom when rains. Agent visual, I mean, if you don't, see it, you smell it, you would note that too in your Avid. But, that's kind of making a conclusion like, there's only a certain extent of the problem. And, I have a case right now where the seller, it was at an open house, seller, listing agent, buyer's agent are there. And the seller says, well, it's a great house, it's been remodeled. I did the kitchen remodel myself. Well, that seller is an accountant, or that seller is a lawyer. I mean, you might want me to write your legal brief in court, but you wouldn't want me to be remodeling your kitchen. So, there's a red flag there. You don't have a duty to verify your seller's disclosures, but if there's a red flag, then you have to ask more questions. So your seller says, I did the kitchen remodel myself. And, you're kind of thinking, well, what does that mean? So what would be your next questions to your seller in that situation? Well, you probably already know what hopefully you know what your seller does for a living. You know if your seller is actually a contractor, or if he's an accountant, or if he's an attorney. So let's assume that he's not a contractor. You're gonna have to start asking questions. Well, in any situation where the seller says there's a remodel, you have to ask, who did the work? I presume this person was licensed, but can you confirm that? And, was this permitted? Those are the types of questions that you should start asking when there are red flags or causes to concern in your seller's disclosure. And then those become the basis for further disclosures, like in the TDS, like in the seller property questionnaire. So if you're at a meeting at your seller's house, walking him through the TDS, and he tells you, well, the guest bedroom actually doesn't have a permit, what do I do? You need to tell him, well, you need to check that box for unpermitted work, and under the explanation section, you need to write, guest bedroom doesn't have a permit. You don't write that yourself, but you need to advise your client to do that.
Brian,
Yes.
can I ask a question before you move on?
Sure.
You said don't disclose, don't adopt the seller's disclosures. Can you elaborate a little bit on that? Do you mean by adopting, that means you just get the seller's disclosure as wholesale to disclose it as a event?
Well, I mean that it's your disclosures are your own disclosures. It's not the seller's disclosures, because the seller has such greater knowledge of the property. So if the seller doesn't disclose that there was repairs done to that back deck, if he doesn't disclose that, but you observe cracks when you're walking around the property, then you better note that in your avid. So those types of things, it needs to be, you should use your own judgment as to your disclosures, obligations as the listing agent, and not just, kind of regurgitate your seller's disclosures. Because keep in mind, the agent, as listing agent, you're governed by Civil Code 2079. This, ties into what we're going through here. And under Civil Code 2079, what do you do? You do a reasonably competent, diligent visual inspection of accessible areas of the property. And that what does it exclude? Well, inaccessible areas, meaning you don't have to, move furniture. Obviously, you don't have to go up on the roof, look for leaks up there. You're in a condominium building. You're not responsible for an inspection of common areas. You're not responsible for anything off-site. And that includes that not required to inspect public records concerning the property, like regarding use or title of the property. But there can be some twists to that particular issue when we start talking about permits. But generally, as the listing agent under Civil Code 2079, it is what you see at the property. It's your visual inspection under 2079 of accessible areas with those limitations just noted. And also with your basic documentation in the transaction. Here we have, I have in my outline prior reports, and that I want to bring up with you that, your seller makes the disclosures, the written disclosure in the seller property questionnaire, of course, in the TDS. They They check the boxes, yes or no. They write in the more details in the explanation section, but what's in that last section of the TDS, there's a question. Now, I'm not reading it verbatim, but essentially it says that the reports, documents, written documents that you have about the property, those need to be provided to the buyer also, because yeah, it's nice to say that we've had termite problems here, but isn't it even better to provide a termite report from 2 years ago? It's nice. It's important to say that we've had leaks in the deck above the kitchen, but if you've had guys out to the property before to inspect and repair those, you have report, you have photos, you have receipts. Those are part of your disclosure, part of the seller's disclosure obligations also. Probably as the listing agent, you don't have those, but it's part of the seller's disclosure obligations. And then when you're sitting with your seller, with the husband and wife in the kitchen, and they're going through the seller property questionnaire, and they get to that last question, and they say, well, it says prior reports. What does that mean? As the real estate agent, as their fiduciary meaning the highest duty of care, which the law knows, you need to advise them that, yeah, if you have photos, if you have receipts, any kind of documents from that plumbing work that you did in that ceiling 2 years ago, that is related to that box we checked on the TDS, you need to provide that also. Because if you don't advise them of that, when they get sued, they're going to turn around and sue you. We call it a cross complaint. But hopefully from seminar, from your experience talking with your broker and your manager, you're going to remember to tell your seller to provide those historical documents about the property. Faxes, correspondence. I'm just going to call this section like, how do you talk to your client? How do you communicate with them? And, believe it or not, actually the case is still ongoing. I had a case with a lady who's buying 4 acres of vacant land. Not in Los Angeles County, it's coastal land up by Santa Barbara. And of course, she sues a real estate agent after she buys it. I'm defending him. He was a buyer's agent. He wasn't dual. So he sent her the seller's disclosures. They were in DocuSign, sent electronically, and he sent them to her and so when we questioned her after she filed the lawsuit, well, this was in the seller property questionnaire. This was in this other disclosure. Didn't you read it? She said, I just received everything on my cell phone and I just clicked on it. So while that makes it easier for us to defend the case, because it looks like she was negligent, she was careless herself in buying this property. But what we got into a discussion with her in her deposition was, well, did you ever tell your real estate agent, I want to receive it by email, or I don't have a computer, or I'm traveling a lot, so I do want it to receive it on my iPhone, my iPad. So the point here is, at the beginning of the relationship, to have a conversation with your client about how they want to receive documents. And actually, let me not say conversation, ask your client in writing in the email, say, so when I send you documents to sign, how would you like to receive them? Should I send them to you by email? Are you comfortable using DocuSign, or would you prefer that if you need to sign a document, I provide it to you in person? Because some people, they'll feel better about receiving in person. They can actually read it. Maybe they're not comfortable using DocuSign, and then you're going to be more protected when there's a lawsuit. So they can't say, well, that's how my agent sent it to me. You'd also want to keep that in mind, especially maybe you're dealing with an elderly person. How do you want to receive the documents? It's another consideration here for you. Okay, and let me. Yeah, here's another important thing about confirming your conversations to your clients, and you don't want to be talking to them like a lawyer, but you also want to have kind of a business formality when you're interacting with your clients. So you met your clients at the property for the home inspection. So you met them there Tuesday at 1 o'clock in the afternoon for a home inspection. You don't have the report yet. It takes the inspectors say 2-3 days to transmit it to you and to the buyer. But that night you get home and you may want to send your client a confirming email where you say to them, it was nice to see you today. I just want to reiterate our discussion when we were at the property that since we saw cracks throughout the patio at the back of that, beautiful home in Encino, California, that you should have a structural engineer inspect the property. I really recommend that you do that. And, here is the name of, an engineer or a soils expert who I've worked with before. So it's in writing. If there's a dispute later about what you recommended to your buyer, as their agent, you have it in writing. Again, you don't have to, write it in a legalistic tone, a nasty tone. You don't have to write it in caps, but it should just be something in writing, confirming the advice that you're giving to your clients. And as an attorney who handles these cases almost every day, it's better to have it in an email rather than text message, because those are easier to recover if there's a lawsuit. And usually in your email, you're gonna have a signature block, which has your name. It says real estate agent, Coldwell Banker George Realty. But if it's only in text, it can be, one, harder to recover. Maybe you change your phone, and two, it might not be clear who is sending it. It just has 2 phone numbers on there. But if you do it in email, it's clear. And then, God forbid there is a lawsuit, some kind of claim, it helps me out with defending it. Let me see here. Okay. So, negligence and that, being a legal word, it's just a legal word for that you owe a duty of care to your client. I mean, that arises in everything we do. We're just driving a car down the street. You have a duty of care to drive carefully. Yeah, you're a real estate agent. You have a duty of care to act carefully also. And as a real estate agent, that means that your standard of care is a degree of care that a reasonably prudent real estate licensee would exercise and is measured by the degree of knowledge through education, experience, examination required to obtain a real estate license. So, what does that really mean here? Well, you're supposed to have general knowledge of agency, legal effect of the documents, appraisal, meaning, valuation. You're not a real estate appraiser, but, based on comparables, you should have a reasonable idea of value of a property. And by that, I just mean, what's a fair listing price? What's a fair offer to make? And real estate practice, meaning, how do you prepare an offer? How do you prepare that avid? How do you prepare, how do you prepare a seller's counter offer number one? Matters such as that. I know you through your brokerage, you have your forms. You're required to turn in documents to your broker. You have your broker, your manager, people like Peter, that you can go to with questions about these things, and hopefully you are. The standard of care, if there's a lawsuit, it's established through negligence. And, what we know through the cases that, have been litigated in the courts is that real estate agent's duty of care is, well, to his or her own client. So you're the listing agent, you're a fiduciary of your own client, and fiduciary, kind of coming from that, old word in Latin, it's the highest possible duty of care. And then you have a duty of ordinary care to the other parties to the transaction, meaning the buyer and the buyer's agent. But the duty of care actually stops, thankfully, with the parties to the transaction, and it stops at close of escrow. And these cases here, like this FSR brokerage v. Superior Court case, what happened in that case is there was, a seller of a beautiful home in Malibu with a deck on it that went over the sand in Malibu, extended out onto the sand. And, the buyer bought the property. A few months later, after moving into the property, had this big party. All his guests came over and they were standing on the deck, and the deck collapsed. So these injured party people wanted to sue people, of course. It's Los Angeles, everybody, it's litigious. And so they sue the seller and they sued the listing agent for failure to disclose problems with the deck. And as to the listing agent, the court said, they said, sorry, you party goers were not buyers in this transaction. So this real estate agent had no duty to you. So if you're fulfilling that duty of care to the actual parties to the transaction, you're probably good. You don't have duties to non-parties generally. And also along with negligence and your duty of care and, talking about the listing side, I'm sure you represent sellers and buyers. But here's another example, from the listing side with your duty of care that, and I call it, my kind of title or, catchphrase for this example is, who is your seller? So, if you're selling that house, it's that, nice house in Encino, it's that nice house in Glendale or Pasadena, and, Joe's selling it. And, Joe Smith, he's the seller, he's selling it, he holds the title. That's an easy transaction. What about Joe and Mary Smith, husband and wife, they sell it? That's an easier transaction. But, what if that property you're selling is owned by an LLC? What if that property you're selling is owned by a partnership? It is more common, if you're in commercial, I'm fairly confident you're going to be dealing with these business entities, LLCs and partnerships. But, what if you are, selling that house? Well, the more valuable the house gets and the more sophisticated the owner is, you're going to be seeing more entities like LLCs owning them. So, you're selling that, $3 million house in the hills of Glendale, and your seller is not Joe Smith. Your seller is, 312 Hillside LLC. And so you're contacted by Joe and he says, hey, I own this property. It's a 312 Hillside in Glendale. And, I want to list it. You say, great. So you go online, you pull up your property after you talk with Joe your first time before you meet him, you pull up a property profile there and you see, oh, it doesn't say Joe Smith owns the property. It says 312 Hillside LLC owns the property. Say, you print that property profile out, or you download it to your iPad and you go and meet Joe and you got that in the back of your head. Well, does Joe really own this property? I mean, can you enter into a listing agreement with someone who doesn't own a property? Of course not. You can't. So when you go to meet Joe, you're kind of thinking, well, does he have the authority to act on behalf of this LLC? So you go and meet Joe with this property and, he tells you, you tell him, hey, I looked it up. It's an LLC. You're the member of the LLC. You're the managing member of that LLC. He says, yeah. I run the LLC. Thinking, okay, that's fine. I mean, and maybe through your experience, or at least I can tell you now, an LLC, it's, it has members. The person with authority to act on behalf of the LLC is going to be the managing member. If your property owner is a partnership, you're probably gonna have a general partner who has the authority to act on behalf of the LLC, of the partnership, excuse me. So you go there and you meet Joe, and he says, yeah, you know, I'm the managing member. I make the decisions for this LLC. So seems okay. So at that point, I mean, are you comfortable that you're dealing with the guy who can sign a listing agreement and accept the offer? Yeah, you know, based on these facts, yes, I'd say yes. You can work with Joe as the authorized, you know, as the authorized representative, the managing member of that LLC. But you know, let's twist this up a little bit. So what if you meet with Joe and you leave him a draft of the listing agreement? You say, yeah, Joe, email me back that listing agreement in a couple of days. If you have any questions, you know, give me a call. But then the next day you get this call from Steve, and Steve says, you know, hey, you know, I'm Steve Jones. You know, I heard that, you know, Joe's trying to sell 312 Hillside. I want you to know that, you know, I'm a 40% member of that LLC, and you know, Joe's not the guy who calls the shots here. So at that point, you know, what do you do? Well, you know, first thing you do is stop. You know, don't go ahead, you know, with that listing, you know, thinking Joe's the guy who has the authority, the legal authority to act on behalf of the entity, the limited liability company that owns that property. So stop. Remember that, and you should have in the back of your mind that, you know, when an individual owns a property, they sign as buyer, you know, or seller, fine, that's easy. But whenever an entity, you know, keep in mind at the end of your residential purchase agreement, there's a box that says, check here if you're signing in a representative capacity. So that box has to be checked on your typical residential purchase agreement. And then there's another form that you check. There's a companion form that goes with it, which is the representative capacity statement, which says, you know, I have the authority to sign on behalf of this LLC. If it's an LLC, maybe it's a partnership, maybe it's a trust. Then you're dealing with trustees of the trust. So that has to be completed. But, you know, thinking about this hypothetical I've given you here, so you talk with Joe, he says he is the authorized representative of the LLC, and the next day Steve calls you. So you have a conflict. I mean, there you can't just proceed with that transaction. You have to stop it. You have to talk with Peter, you have to talk with your manager, you have to talk with someone else, you know, within your brokerage above you to consult on these issues. And at that point, if you ask me, you know, I'd say you need to tell Joe and Steve that they have to provide you with a copy of the operating agreement for that LLC. Because there's red flags. Where there's no red flags, you don't have to ask for that, but you have to ask for a copy of that. And you have to be talking, you know, with Peter about this. And there needs to be, you know, an evaluation of this by an attorney at that point, because I you know, defended cases like that, and you just, it's going to be a substantial lawsuit if you're in a situation where you've opened an escrow on a property with someone who you think has the authority to sell it, but really doesn't. And then, you know, Steve, the guy who says that he holds the 40% interest in that LLC, he's probably going to get an attorney and say that, you know, this real estate agent here and Joe were in this conspiracy to, you know, sell this property without my consent. And, you know, certainly don't want to be in that. A similar situation, really briefly, I'm going to allude to is this could come up with the elderly person. You know, you go to that nice old home in Encino, and you know, it's the oldest house on the block. It's, you know, they're building all these mansions around it, and you meet, you know, this old gentleman, you know, there's John, he's lived in this house for 50 years. He's kind of, you know, it seems like he's not as with it as he used to be. So you go to meet him, and you bring that listing agreement, and his son's with him, and his son, you know, Bill says, yeah, you know, I signed for my father. You're thinking, okay, I looked at the property profile. I saw that, it says John Smith is the owner of the property. It doesn't say Steve or Bill Smith is the owner of the property. So then, you've got some red flags. You need to ask that son, do you have a power of attorney? Is there maybe some other legal authority that you have? And at that point, I would also advise you to consult your broker. Let's go through some other examples here. Okay. Okay, so with permits, here you're on the buyer's side. So how do you fulfill your duty of care to your buyer where there's a red flag with something not being permitted on the property? Shorter answer is you gotta be careful here. You also gotta recognize the limits on your role as the real estate agent. So that TDS says the pool room, let's call it the movie room at the back of the house. That room was just added on. That one doesn't have permits, and there's some other work at the property where there was an unlicensed contractor. So that's in the TDS. So that's a red flag for you as the real estate agent for the buyer. You're required to investigate that. So what's the first thing you do? The first thing you do is you've got to email that listing agent, and you've got to say, I need you to tell me more about how that movie room at the back of the house was built. Are there permits? Who did the work? How long ago was it done? Do you have a contract with that contractor who did it? Did you even apply for a permit? Do you have receipts for the work that was done? So are there building plans? So you need to ask for all the documents related to that work that was done. And when you need to press the listing agent for this. You need to follow up with them if they don't get back to you, of course. And then, with that information, you need to provide that to your client, to your buyer, in writing, of course. You're getting the documents. Maybe if they're provided to you as attachments in email, great. Forward them on to your buyer. And you need to review them yourself. And at that point, unless it really is clear what was provided by the listing agent, the best practice is for there to be an investigation of permits with the city, with the county, whatever the agency is that has the jurisdiction over that property. At that point, you need to advise your buyer in writing, in an email, to, I want you to, I recommend that you investigate permits for this property. It's the city of Pasadena. Here's their website. Here's their phone number for the building and safety department. Please look at their website and investigate permits. It's important for this transaction. So that email should go out to them. There's some real estate attorneys, and some attorneys would say, well, the real estate agent has a duty to go do that himself. Don't tell your client to. The real estate agent's responsibility as the fiduciary is to go him or herself and investigate those permits. But my advice is recommend it in writing to your clients to investigate those permits, and that should be your first step. So, but why would that be your first step? Because as a real estate agent, you're not an expert in permits. You're not a real estate attorney. You're not a permit specialist, a permit consultant. You're not a contractor, things of that nature. So if you're going yourself to investigate those permits without first offering it to your client, recommending to your client that you do it, you're going into some uncharted waters there. So recommend it to your client. If they come back and tell you, I just don't know how to do this, I can't figure it out, then yourself go onto the website, pull up the publicly available documents that you can, call into the city, find out what you can, provide that to your client, and stop there. Then tell them in writing recommend to them, you need to have a real estate agent review these permits and documents from the city. It's really beyond my expertise to do that. I recommend you have a real estate attorney, and that's in the buyer's inspection advisory. So use the forms that have been provided to you. So you're not just advising your clients yourselves, but that's in the buyer's inspection advisory. Use that form. I've got one more interesting example here for you about a buyer's duty of care here. And also, I'm going to just go down to this section of my outline about fraud and deceit. And it deals with a case I'm working on right now. Buyer's agent, they meet the buyer, husband and wife. They seem to be a really nice couple. They tell them, yeah, I have this money to buy the house. There's, this house is listed at 2.4 million. And this buyer says, yeah, let's write that offer. And by the way, write it as a $2.4 million all cash offer here. So, and you think, wow, that's great. I'm gonna be the buyer's agent. We're gonna close this transaction here. So you write the all cash offer. And so the issue then is, do you have any duty to verify or investigate your client's ability to put up that $2.4 million cash? And the answer is no, not beyond reasonable representations to you, not beyond a proof of funds. So when you provide that offer, it says on that first page, I think it's paragraph 3, all cash, 2.4 million. You're going to provide it with a proof of funds here. And the proof of funds, it's going to be, something that has your buyer's, full legal name on it. It shows their address. In the case I'm working on, it was just, the proof of funds was just a screenshot, which showed like a username. And then it said that this buyer had $2.3 million in there. So what happened in this case was this buyer provided the proof of funds with the screenshot for 2.3 million. And 3 days later, they were supposed to provide a $71 million deposit. Well, they weren't able to. Seller gives extension, seller gives another extension to provide the deposit. Eventually the deposit's made, but this buyer could not come up with about $2.2 million cash to complete the transaction. So seller accepts that offer, you go into escrow. By the time it's extended, it's about 60 days of that property is in escrow. Other buyers had been making offers before this offer was accepted. And this seller says, then this buyer cancels. This seller says, you tied up my property for 2 months. I had all these other buyers with comparable offers. I turned them down and, I didn't get them. Now those buyers aren't around anymore. And, you prevented me from selling this property. So, buyer, you perpetrated a fraud upon me, and buyer's agent, you assisted in perpetrating the fraud. I'm going to sue both of you. The lesson to be learned here is one, well, buyer's agent, you don't have any duty to investigate your buyer's finances as long as there's a reasonable appearance and you provide a proof of funds that also has, their name, their address on it, that has a reasonable appearance. But you're not required to contact your buyer's banks, their investment firms. Those entities wouldn't even release their information to you without, a written consent form. And just two, the other thing to be careful is, yes, of course, you are going to present your buyers in the best light. You're going to say they're great people. They're they'll really love this home. You're going to say they have the ability, they have the financial ability to close this transaction. But, in short, don't go overboard with the description of your clients as to, how wealthy they are. And rather than saying your clients are so wealthy, just show them. So your email should not say, these are the ideal buyers. They are very wealthy. They will definitely be able to close this transaction. Your email should just say, These buyers are great people. Based on what they have presented to me, they have the financial ability to close this transaction. Attached is a printout of the statement from their investment account at Fidelity or Vanguard or whatever. So don't represent yourself that they're so wealthy. Just show them through the documents. You know, the last thing I want to explain, I want to tell you about is that always as a real estate agent, buyer or seller, you're a fiduciary, and any profit that you're going to receive from a transaction in any way has to be disclosed to your client. So your commissions on the settlement statement, of course, they're going to know about that. But, you know, what if you're representing that, you know, the elderly lady with that house in Hollywood, and, you know, she's selling and she sells to a flipper, and you're a dual agent on the transaction, and this flipper is going to, you know, buy the house. He's going to sell it quickly again in a month. And, you know, you're going to get commission on both sides. But, you know, on his website, he does so many transactions. He wants to attract real estate agents. So on his website, it says, and it actually tells you, you know, in addition to commission on every transaction I close, I pay the real estate agent an extra, you know, 2%. You know, if you receive that money, your seller must be informed of that in writing before close of escrow, because as a fiduciary, anything that you know, your client has to know. And so that's about an hour here that I've been walking through these issues with you. I hope it's been helpful. I'm going to email my outline to Peter. He can send it to you if you'd like. And I have a few minutes if there's any questions also. So thanks so much for spending this time with me today.
Thank you, Franz. Really educational. But I have a couple of questions. Now, we all know that, you know, in the real estate, it's a statute of fraud. That means everything has been in writing. You know, the purchase agreement, you know, the any lease over 1 year or any guarantee for somebody's debt, it has to be in writing. But how about the commission agreement? Now I know that you know, in the according to CAR, it's recommended that you should put everything in writing, you know, including the commission agreement. But legally, are you required to have the writing, the commission agreement in writing?
Well, you're going to have your listing agreement, of course. As to the buyer's side, you're not required to have it in writing with them. There is the CAR Foreign Buyers Representation Agreement, which can be used, which can be used as a strict legal requirement. You know, you have to have your agency disclosure forms, of course, and you know, your commission. It's going to be in writing, of course, in your settlement statement and escrow instructions. But, you know, is there a statute that requires you to have the buyer's representation agreement? No. But, you know, of course, it's the better practice to have that in writing. And in the example I finished up with, you know, in that situation, you're getting sort of this extra benefit from the seller. You know, your buyer is not going to have any way of knowing about that unless you tell them, and, you know, remember to put that in the email.
Okay, thank you. Another question is that if you have a power attorney, you know, see if the father has a power attorney to his sons to sell the property, and the father died before the closing of escrow, the power attorney is no good after his death, right? After the father's death, so he cannot go ahead and close escrow on the son's own action. It has to be defer to the estate of that person in order to finish the closing of escrow, right?
I believe that's correct. Yes, I mean, the power of attorney, you know, is for someone who's living. You know, and you know, when there's the passing of the owner, yeah, then you get into the issue of probate, the will, trust documents such as that, and that is definitely a point in time where you need, you know, an attorney involved to advise on those issues.
Now, what if there's a little twist that if if the father was seriously ill and he signed the deed of trust, I mean the grant deed before he passed away, then after that, does the son, can the son go ahead and close escrow?
So if he signed the grant deed,
Yeah, if the son he signed the grant deed while the power of attorney was still in effect before the father died.
well, I mean, it may not be able to close because you have, I mean, because, you could have a provision in an estate planning document, in a will, in a trust that says upon death, someone else, becomes a successor owner. So you would definitely want in that situation, want to have the will, the trust, any estate planning documents before you and review those. I mean, because if there's a death and there's a provision in a trust that says that, in a will that says, upon death, this person becomes a new owner and escrow hasn't actually closed yet. I could see that to be a problem if escrow could lawfully close.
Yeah, but legally, the property has been transferred before the death of the father. So that the transfer is still legally done, I think.
Well, if there's the grant deed and that's been signed, if that constitutes the transfer, then maybe that's right. But if escrow hasn't recorded it, if the final settlement statement, if all those final escrow documents haven't been, all the escrow documents haven't been signed and recorded, then there could be room for someone to raise an objection there. And that probably what it does is it comes up in the case where you have the father has 5 children and 2 of them get along and there's 3 of them that don't get along, and and that one child who moved away and doesn't like the other siblings, he wants to stop it. So in one of those situations where there's some family difficulties, I could see that is probably where it would come up, and that's where it might be more of a concern.
Yeah, you're right. I agree with you. Last question. Now, in the RPA, one of the contingency, say if you have one of the contingency that escrow will only close if the seller is successful in evicting the tenant. But because of the COVID situation, it's impossible to evict the tenant in the near future. And so can the seller cancel the contract based on the impossibility or impracticality of performance?
So okay, so there's an express contingency in the RPA, and it says that close of escrow is contingent on, it's a rental property, and close of escrow is contingent on seller evicting tenants. In that situation, I mean, the general rule is if you have a written contingency, it's a contingency in a contract. And, unless it's waived or removed, the contract doesn't proceed. In this situation, with evicting a tenant, and that's even tough. Everyone knows that's so hard to do these days with COVID.
The eviction attorney said that, well, it's impossible to do it now.
Right.
It's a situation with COVID. So
I mean,
what are you going to do?
Yeah, from this hypothetical, I'd say the seller has a good the seller's in a good position for not having to close.
Right, but can he cancel escrow? I mean, can cancel the contract and market the property to another buyer without that contingency?
Well, if it's an express contingency there, I mean, he has the right to cancel it. So I would say in that situation, probably yes.
Okay, all right, thank you.
Brian, can I make a quick question? My name is Alex.
Sure, go ahead.
If I have a business card or trying to do advertising, I'm a realtor and I've been for so long in this business. So if I put, for instance, Alex Realtor Wealth Creator, that
What-
is any like any problem because I'm putting the word realtor and I'm adding, just to call the attention of customer client, say wealth creator.
You said
the
wealth
word
wealth
realtor-
creator?
Yes, next
Wealth
to it.
creator. So, the issue is, so I mean, is wealth creator like a particular job or occupation? I would say that's okay because it's just like more of a description of what you do in real estate. It's not like saying, Alex, real estate agent and CPA, or real estate agent and business advisor. So, I think business advisor gets into that gray area, but, with wealth creator, I mean, if it's real estate agent and wealth creator, I'm not worried about that. No. I mean, but then, I don't know if you have different emails and cell phone numbers for wealth creator versus real estate agent, that could get more confusing. But if the card just said, real estate agent, wealth creator, I think that's okay.
Thank you.
This is Camelia. I have a question. You said that sellers are required to provide past reports. If I get a seller that tells me, well, I removed the popcorn ceilings 25 years ago when I first moved in and there was no asbestos, do they need to provide that report? Is there a reasonable time frame that passes before you say, okay, that report's kind of old?
Right. That's a good question. So the material facts for the property, it's, does it materially affect the value or desirability of the property? So, I mean, if there's any slightest indication of any current problem related to that report of the property, then yes. But, with that much passage of time and, assuming there's no current issue at the property, because it's 25 years ago, I'm going to say that's not required. But, as you start getting into 15, 10, 5, in that area, I'd be leaning towards a yes, you need to provide it. In as you get into that, like 10-year period, I think in that area, I'm leaning to, I'm going to say yes. But if it's, 25 years ago, I think you're safe to say no. I mean, the classic case I had was, if it's a flipper with the property and they bought it 18 months ago, that's a definite yes. But assuming there's nothing in the current condition that is a problem related to that, with that much time passing, I think it's a no.
Also, I wanted to point out that there's some people who have written their questions in the chat, if you wanted to go through those.
I did not really see those yet. Okay, so let me see those. Oh, the first one is easy. Are we going to have any handouts? Yes, I'm going to email this to Peter. How far do sellers need to provide past reports? And that goes to, well, it goes to first, how the material. Remember, disclosure of material facts. Does it have a effect on the value or desirability of the property? That's what defines material facts. And how far back, recent years, a year or two. I'd say when you get beyond that 10-year period, you're getting into a zone of safety. But I would use 10 years as a time period. But if there's something in the property currently that in any way relates to that mold report from 15 years ago, then provide it. Okay, to Gary, Tom, agent or seller need to do on this. Okay, well, let me answer the agent completing the admin does not see any defect or item of concern. Is best to leave that section blank or write nothing. Yeah, I like the nothing noted. Yeah, whenever I see that on an Avid, yeah, I think so. If you go into a room, you don't see scratches, you don't see stains on the wall, you don't see screens missing, just write nothing noted. Yeah, leave it at that. When the seller is blind, well, let's see. Well, then, seller, you need to ask, is there any, anyone else in the family that could help you? Do you have anyone else? Whenever your seller has some type of, maybe it's blind, maybe they're elderly, maybe there is some kind of, English is a second language, then, the spouse, if it's someone married, some other family member, reach out to another family member to see if they can be of assistance. That would be the preferred way of handling it there. Speak English, write English. Write it for him. So again, I mean, this is a similar, this is, basically a similar question. So if your seller, is somehow not, of the ability or, capacity to do this transaction, well, the first thing is, I mean, so if your seller is like, 80 years old and, has like Alzheimer's and dementia, and you really think this person doesn't understand anything, then the question is, should this person really be selling their house? And should you really be working this person as a real estate agent? Because if this person can't understand what you're saying and communicate with you and fill out, these CAR forms for you, that's a high risk situation for you, because, that son, that daughter, someone else in the family could come back later and say, you told my father to sign this and this shouldn't have been done. You took advantage of him. So, can't speak or write English. Can you write the TDS for him? The first thing you do is see if there's anyone else in the seller's household who can do it. If you feel that the only possible way that it can be done is for you to write on the TDS, so have your seller write out the explanation section, in his or her, native language, whatever it is, and then take that explanation section, then just translate it exactly into English, and then write it in the explanation section. And as to the questions, yes or no, so you could read the TDS to your seller, and where it says, are there any neighbor issues? Have there been any prior lawsuits related to this property? Have there been any insurance claims? Is there noise from an airport? Where you go through your TDS and SBQ, you could read those to your seller and he or she could say yes or no. What about in that situation? Here's a helpful tip, like bring a co-agent with you to that meeting. So, because you don't want to be in a situation where your seller, or someone says, well, no, that's not what the seller said to you. So if you have to go with that approach, bring a witness with you, bring your transaction coordinator with you to that meeting, bring a co-agent with you from Coldwell Banker to be with you as a witness to what's happening. I think that's an alternate approach. The how far
Hello.
back?
I'm sorry. My name is Sylvia
Yes.
Rosich, and
Yes.
I just wanted to comment on a situation I had some years ago, dealing with the Spanish-speaking seller and his wife, and I know that the CAR forms, I haven't checked lately. Again, I haven't had that situation, but I know I had a document called the translator, so that or interpreter. Whenever they don't speak English, we are told that we're not supposed to translate that for them. They have to have somebody as an interpreter, family member or someone other than ourselves. We cannot translate the forms. We have to read them as they are and let them know what they are, how they what they read, so that they can then make their own conclusion. We're not supposed to translate them, because if later on something happens, then that's on us. You know, they can take us to court because of that, right? So I think that form's still in the car forms for us to be able to use, I think.
You know, I'm not sure if that form is still there. I could look it up, but I haven't seen that form recently, and it may still be there. You know, but certainly, you know, if I would go to a family member first, you know, someone who they trust, try to keep yourself out of the situation of completing the form for your seller or translating it. And then if you're going to get into a situation where there's a lot of questions from your client, and then if you're translating, maybe you're not, you know, translating the form literally, but there's some, you know, there's some translating that you're doing. So it sounds like my sound is going out, but I mean, the danger here for the real estate agent is someone's going to say, you know, that's not really what I said. But if you have another witness with you, you're more protected.
Right.
Yeah. Okay. And then I think there was another question. Owns the house for 3 years. So, and do you still have an, so the seller, I mean, so this last question says it's from CH Carol Hugh, I think. And I mean, in a typical, you know, absent, you know, specific requests from your buyer, specific demands from your buyer, you're selling a house, you're not required to, you know, hand down every permit that exists for the property. You know, so you just complete the TDS and the SBQ, you know, based on what, you know, your seller does, you know, honestly, but when you complete a TDS, you're not required to, you know, provide a package of permits with it. And where that comes up is where there is something that's disclosed, which is a red flag. And then the buyer's agent comes back and says, yeah, you know, show me more in that situation. So, and then, you know, with regard to, you know, renovations and remodels and permits, you know, if there is, with permits, it comes up more with the red flag. And with renovations and remodels, based on the last part of the seller property questionnaire, it's one of the last questions on there. You do need to provide reports, receipts, things like that. And then as to how far back, it goes into, you know, what we're talking, like a balancing of how material this could be and how far back it is. So, and anything else?
Yeah. Anything else for Brian? If not, then we will thank Brian for such an educational webinar.
Thank you very
so
much.
And
Thank
yeah,
you so
hope to see
much.
you again.
Thank you, everyone. I really enjoyed spending this time with you, and I hope you have a successful year and a safe and healthy one too. And I'm emailing the handout to Peter. And you know, if you look at, you'll see my firm's website is on there, and you can pull me up on the website and feel free to call me or email me if you have any other questions or anything else you want to talk about with the transactions. Thank you. Thank you, Peter.
Thank you. Thank you.
Thank you.
Very good.
Thank
Very
you
good.
so much.
Thank you.
All righty.
Thanks, everybody. Bye-bye.